Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. What happens if you have a marital home in a divorce? If the home was bought during the marriage, it's no problem, right? It's a marital asset. It gets divided. Whatever the equity is should be divided, presumably in half. Well, what if the house was purchased before the marriage? Well, the presumption is if it was purchased by one of the parties before the marriage, then it's really, at least in part, off the table. That is, the value that existed beforehand, that's not a marital asset. Potentially the growth during the marriage would be a marital asset, and that piece would be subject to division. So what happens in a situation where, let's say, wife had the house a year before the marriage, then you get married, house is still in her name, but all the while, you've contributed to it. You've made payments, you've done this, you've done that, you've caused the equity in the house to grow. Well, if there's a divorce, she doesn't really have the right to come to court and say, it's fair that all the accumulated equity should go to me. Why? Because it was mine before the marriage. No, the court will probably not do that. More likely than not, the court will say, okay, it was worth $100,000 before the marriage, that's yours. It's now worth $150,000 because of growth in the marketplace, buying down the mortgage, different kinds of things. That $50,000, that extra piece is marital, subject to division. $25,000 is yours, $25,000 is his. So it goes. That's more likely than not how the court would approach an asset like that. If you have any questions, reach out and we'll be glad to help you out.